Hi everyone, this is Tracy Koch lecturing on Chapter 17 from our textbook, Financial, Ethical, Legal, and Social Considerations, and this is as they relate to genetics. So this chapter focuses on more the sociocultural aspects of genetics, and with the advancement of genetics and increased access to information, we have more complex legal, financial, and ethical considerations when dealing with genetic testing, the distribution of the genetic information, and of course we'll touch on some discrimination and challenging decisions that surround clinicians and patients in looking at genetics and genetic testing. Genetic information is a little different than other kinds of health information. It actually I consider to be a little more sensitive than other medical information in many ways, because the information not only pertains to the patient but also potentially to the family and offspring of the patient. So it is a little bit different than your run-of-the-mill medical information. Ethical goals of clinical genetics, this is kind of the guiding principle, if you will, is to really respect patient autonomy. Our role really is to assist families in making decisions and not really say a right or wrong. So non-directive and supportive counseling and assisting families in making an informed decision is really our role as nurses. Genetic discrimination is the fear of being discriminated for having a certain allele or a certain genetic trait. Luckily, we have legislation in place to help protect patients and families for this, but it still is a consideration when talking to families about genetic testing. Reasons for not having genetic testing might be fear of losing health insurance, fear of paying a higher premium, or fear of actually losing employment, and we'll talk a little more about that later on in the slideshow. Legal, ethical, and social issues, or ethical, legal, and social issues. ELSI is the acronym for that. The Department of Energy and National Institutes of Health designates a portion of the budget for the Human Genome Project, ELSI and FELSI. Those are the acronyms of the funded programs. Ethical, legal, and social issues, and financial, ethical, legal, and social issues are the words for the acronyms. But they're funded programs, and they the Human Genome Project set aside 3% to 5% of their annual budget to study this. It's the largest bioethics program in the world, and they've also considering the financial aspects of genetic testing. So it's a group funded by NIH and Department of Health, and the group studies all the legal, ethical, financial, and social issues of newly available genetic knowledge and how that might confront patients or how it might impact patient care. So that's what these agencies will focus on. Eugenics is really a very interesting concept. It is improving humankind by selectively breeding people who have, quote, good genes and not allowing reproduction of people with, quote, bad genes. It took place in the United States in the years of 1910 to 1940. The US and UK were really two countries that focused on this, and it was actually led to the sterilization or the thought of sterilizing socially inadequate people, and there's a website on the slide here. So when I looked at this concept, I thought, well, I really don't know much about this, so I kind of, looked into it a little further, and it actually gets its origin from Greek roots. The word eugenics gets its origin from Greek roots, good and generation. So back in 1880 is when the movement kind of picked up momentum, and through the 1920s and even the 1940s. The movement was scientists who looked at Mendel's work and the crossbreeding of pea plants and his writings on that, and thought, one sector of these researchers kind of looked into eugenics by thinking, using a mathematical science to predict certain traits in human beings, and then that led to kind of this movement to control human breeding. One of the scientists was Charles Davenport, and at that time he was very respected, and he kind of spearheaded this movement, thinking if you can genetically predict, pea plants, then you can genetically predict people. So the premise of his work was that certain racial stock was superior to others, and values were placed on traits like intelligence, hard work, and cleanliness. So folks who had those values were considered to be were better breeders, or better genes that he thought people should breed. And the overall goal was to promote better breeding and prevent poor breeding. There were even fairs, like a county fair, that had prizes for the finest human stock. And this, no kidding, I looked this up. Eventually, there was some legislation passed in 1924 that actually set quotas from certain countries that the eugeneticists thought to be inferior stock. The movement picked up even more momentum in Nazi Germany when institutionalized eugenics was practiced. So it really does have this interesting history, if you will. And I got my facts from PBS's website. So if you're interested in looking that up, it is kind of, it's one of those things that you look at and it's just unusual. I'll leave it at that. But now we have an Immigration Naturalization Act that's much more complex laws, and we don't have that 1924 restriction that they had passed. Actually, I did Google the word eugenetics, and you might be interested to know there are still some organizations today that focus on breeding of higher intelligence. So there you have it. It's an interesting concept. So moving on, we're going to talk about pre-implantation genetic diagnoses, which we sort of touched on back in Chapter 14 when we talked about genetic testing in general. So this is more looking at pre-implantation, looking at embryos, looking at the genetic makeup, quote, designer babies, and what happens to our defective embryos. What do we do with those? Different people have different views and different values on what to do with this sort of information. So it can get to be kind of a sticky wicket when we're talking about it. It also has some impact on people living with disabilities. What are the value of their lives, and is this a form of genetic discrimination? These are some really difficult questions to ask and answer, and I think it's a case-by-case basis for most people. But it is something that you may or may not be confronted with depending on what line of work you get into. But this is another piece of ethical dilemmas that we might have in the world of genetic testing. The history of genetic discrimination goes back a long ways. Some of the more famous cases we'll discuss here: the Burlington Northern Santa Fe Railroad tested employees for a genetic predisposition to hereditary neuropathy with liability to pressure palsies without consent. It's a genetic risk for carpal tunnel syndrome, and the lawsuit was filed by Equal Opportunities Employment and Commissions when they did this. So what happened is the folks at Burlington Northern Santa Fe tested their employees for this condition, not telling them that's what they were doing. The point of this, that for the railroad, they were hoping to correlate some of the workers' compensation claims for carpal tunnel syndrome to a genetic predisposition rather than having them be work related and then having them have to draw on workers' compensation. So that was there was a lawsuit filed on that and found in favor of the workers. There was also a woman with hemochromatosis. She lost her health insurance, though she had no clinical disease. She had a low penetrance, so no clinical disease. She had lost health insurance. There's a family who lost health insurance for their son with Fragile X syndrome, and a man who was denied employment because he had one copy of an allele that causes Gaucher's disease. He was an unaffected carrier, had no symptoms, but they denied him employment anyway. So you can see there are a lot of cases, and there's some more in your textbook, and certainly if you look into it, you would find many more cases of genetic discrimination. The Genetic Information and Non-Discrimination Act, GINA, was signed into law on May 21st, 2008, so not really that long ago if you think about it. This offers federal protection against genetic discrimination in employment and insurance. And there's the link to their website on the slide. The GINA Health Insurance Protection Plan, you cannot use genetic information to make decisions about eligibility, size of the premiums, or the extent of their coverage. You also cannot use genetic information as evidence of a pre-existing condition, and you cannot require that a client have genetic testing. It's illegal for employers to use genetic information to make decisions about hiring, promotions, and termination of employment. So it really is kind of all-encompassing and protects the patients and consumers. Protected genetic information are the results of one's own genetic test and those of family members, any clinical signs of a disease in a family member, or whether or you and your family have requested genetic services. So that's the categories of protected genetic information. Duty to warn versus the right of privacy. This is another sticky wicket. We have HIPAA requirements where we are not to share patient information. Beneficence, patient autonomy, and what do we do when all these principles collide? So this is really getting into a person has information about their health. There might be a genetic implication for further generations or even family members, and what do we do with that information? What's our obligation as providers? What is the patient's obligation, and what's the patient's protection? So it's very complex. It's not a simple yes or no answer. So in this case, Pate versus Threlkill in Florida, a physician was sued for not warning a patient's daughter of her genetic risk for thyroid cancer. And this case is also discussed in your textbook. The daughter was later diagnosed with advanced thyroid cancer, and she claimed that had she known of her risk, she would have an earlier diagnosis. It was the physician's duty to tell her, to tell the patient to warn her daughter. So even if the doctor didn't, or the physician didn't disclose to the daughter, he or she should have discussed this with the patient and had the patient actually warn her daughter. Safer versus Estate of Pack, and this was in New Jersey. 30 years after her father died, a woman sued the estate of her father's physician for failing to warn her of risk of familial adenomatous polyposis, so polyps, basically, telling the patient, so she sued because the father was supposedly informed that he had to tell his family, but that is not enough. They must take reasonable steps to assure that the risk is communicated to the rest of the family. So this was another well-known case where genetic information was seen to be withheld from the offspring or the family. In Malloy versus Meyer in Minnesota, this is a little bit different twist on a case, but there was a family who had 2 children. The first child did not have any genetic testing on them, so they had a second child with Fragile X, and the argument was that the first child should have been tested and was not. So there was some onus on the physician who should have performed the diagnostic genetic test on a child with a cognitive impairment and to see if they had a genetic condition. So those folks sued also. In the United Kingdom, they have the General Medical Council. The physician can disclose genetic information without a patient's consent when it will benefit a family member. This is only if the patient has refused to warn the family. So this is what they do in the UK. Institute of Medicine and the Presidential Commission in the US has come up with this guideline, when it is acceptable to disclose private health information, if it's very likely that harm will result if the information is not disclosed, and harm from not disclosing the information would be greater than the harm of disclosing the information. So again, I think that reasonable communication and looking at the risk versus benefit certainly would come into play when talking to patients or having sensitive genetic information that you may or may not have to pass on to family members. Next, we're going to talk a little bit about intellectual property rights and gene patents. This is really an interesting, I think, concept. Scientists who discover certain genetic findings or genetic information, they typically are employed by someone, so the government will permit those folks to patent the output of their created work. So the U.S. Patent and Trademark Office has agreed that to patent isolated sequences of the human genome. So the issue with this is it could limit access and increase the cost of genetic testing. And it's unlikely that gene patents will continue. They're kind of looking for some middle ground so that the scientists and the companies get recognized and they get the benefits from their creative work, but we can't do that at the risk of penalizing patients and maybe making the test for such genetic findings, so cost prohibitive that people can't participate, or the access to it is so low. So they're still working on finding some middle ground between those two, but now you can patent isolated sequences of the human genome, which I just find really fascinating. Okay, that's the end of our slideshow, and there is a case study.